Good morning, everyone, and welcome. My name is Gina Petrimurillo. I'm your moderator for today's session. You are in room C, featuring the workshop entitled Including Children's Voices in the Parenting Time Mediation, the Peel Child and Youth Informed Mediation Pilot Project. I practice it, so I'm fumbling a little bit. Our presenters are Antoinette Clarke and Jane Long. If this is not the workshop that you are intended to be in, please click the link in the chat that will take you back to the main room and someone will help you get to where you need to be. This is where you are. Welcome. Thank you for joining us. If you experience any technology problems during today's session, again, please log back into the Zoom link for the main room and they will help you get back to us or where you need to be. Please make sure your mics are muted, and Jane and Antoinette will take questions at the end of their presentation. I send it over to you, Jane and Antoinette.
Thank you. Thank you.
Thank you.
Gina. Okay.
So welcome. Hopefully you're where you want to be. My name is Jane Long. I am a lawyer at the Office of the Children's Lawyer in the Personal Rights Department. And Antoinette, do you want to introduce yourself?
Yes. Morning. My name is Antoinette Clarke, and I'm the Executive Director for Peel Family Mediation Services.
And we're here today to talk to you about a pilot project that we're both involved in, and it's the Child and Youth Informed Mediation pilot project. So Antoinette, do you want to describe how the pilot works or how the program works?
Yeah, I think I'd like to start first by saying a little bit about Peel Family Mediation, which is one of the court connected services within the Ministry of the Attorney General. And we started this since 2011 and have been providing mediation services for the Peel and Orangeville communities. We provide mediations in the court and mediation outside the court, and we provide mandatory information sessions for those families who are involved in the court. So you want me to start, Jane, about the pilot and how it got all started?
Sure, that'd be great.
Yeah. Okay, so this pilot came about as a result of some conversations with myself and at the time, the clinical director for the Office of the Children's Lawyer, Andrea. And we started with a steering committee because we were thinking, we in the mediation service, we had sort of read the UN Convention about the voice of the child, and we were very aware of the voice of the child reports that the Office of the Children's Lawyer were already providing. And we thought about how we can include the voice of the child in mediation. So we started that steering committee, and we started to discuss, is it possible to basically look at how the child's voice can be involved in mediation without the mediator interviewing the children. So I invited Andrea and we started to talk. We talk about how the possibilities of how basically it could work. So we had that steering committee which was made up of members from the Office of the Children's Lawyer, a clinician, and Andrea, members from the Peel Family Mediation Services. So we start to put together a framework whereby we can offer this service. There were some critical issues that we had to basically address and discuss, because one of the things is that the services provided by the Office of the Children's Lawyer, their services to the public are free. The mediation services, unless the mediation is held at the courthouse on the day of court, the services are not free. There is a sliding scale fee. So we had to talk about how could this be possible, because we had to do something that was free to anyone that's involved in the project. So we had to be involved with the Office of the Chief, to get permission in order to be able to do that. So we basically worked through it, no additional funding to any of the services, and decided that we would basically put this together, whereby we will do the mediative pieces of the matter, the parenting pieces, and the Office of the Children's Lawyer will do the interviewing, because they have the specialists, and that they will do the interviewing of the children, and then look at how that is possible. So we'll share with you later on how that actually works. But it stemmed from the UN Convention to the Rights of the Child, giving the child a voice, kind of indirectly how we're doing that. Next slide, Jen. You want to add to this, Jen?
Yeah, I'll just go back a little bit for those of you, if there's anyone who doesn't know who the Office of the Children's Lawyer are, who we are. We're an independent law office within the Ministry of the Attorney General. So it shows how independent we are, that Antoinette's program is funded by the Ministry of the Attorney General Court Services Division. We're a separate office. The children's lawyer, for those who don't know, is Diane Carter. She's been the children's lawyer since May the 1st of last year. We have legal and clinical panel members across the province who work with families and children. The clinicians are typically social workers, but some are psychologists. And in parenting time cases, clinicians can conduct investigations and prepare reports. They may prepare focus reports on a specific issue. They can interview children and prepare voice of the child reports, which I'm referring to as VOC reports. And they also assist lawyers in representing children. And then in some cases, we have lawyers who represent children. For those of you who are in the CAS world, you'd be familiar with working with children's lawyers, but not necessarily clinicians. And Antoinette's already gone into this in terms of why we thought it would be a good idea to include children. I think it's a fairly obvious statement that parenting time decisions directly affect the children involved. And then the legislation in both the Divorce Act and the Children's Law Reform Act direct courts to consider the child's views and preferences and giving due weight to the child's age and maturity unless they cannot be ascertained. So we always like to say that children's voices aren't determinative, but they really are important and should be considered by people. So we've already talked about the UN Convention on the Rights of the Child. Also, just by way of background, again, those of you who are involved in the child protection world are aware that since 2006, OCL lawyers have been providing representation for children and young people in child protection ADR. So there is a fair amount of familiarity amongst our panel members about how to be involved in an ADR proceeding as an advocate on behalf of children. Antoinette, do you want to get into you've talked a little bit about the purpose of the pilot project, but do you want to go into that a bit more?
Yeah, and if I can just say too that, one of the reasons that we thought hardly about looking at a project like this has to do with our experiences with some teenage children, older children, when they are, even some of the parents that go through the mediation service, when they say that they wish that they had services like these when their parents were basically going through this process. So it's sort of stronger reason why we would want to establish something like that. So we wanted also to put some best practices into place. And as I said earlier, the Office of the Children's Lawyer, that's a free service. And they are involved with families when they're referred by the courts. So the courts might decide that this case suits the Office of the Children's Lawyer, and then Office of the Children's Lawyer make a decision about if they are going to be involved with the case and whether it will be a clinician or a legal practitioner. And for us, Also, we do get referrals from the court, from the justices. We are supported by the OCJ and the SCJ justices. They make referrals to mediation, sometimes on the same day of court, or sometimes after, where it comes to us. So we wanted to basically develop an efficient process whereby we could engage parties to assist them in reaching an effective resolution that works for the children and basically works for the whole family, where we can have better relationships between parents and children. So that was the purpose behind the pilot. Okay, next slide, Jane. Why did we choose Brampton? Well, I basically, as I sort of started it and approached Andrea and OCL about it. And as I said, we provide services for the Peel community, which covers Mississauga, Caledon, Brampton, and the Orangeville, Dufferin County areas like Shelburne and those. So those are the two areas that our mediation services cover. And they're very diverse population with a wide, with people from all over the world, with different racial and linguistic issues that need to basically be addressed. So we thought that it would be a good blend, and also Office of the Children's Lawyer service those areas as well. So we thought that it would be a good fit for the two of us to come together and look at what we can do in order to offer this service for families. Next.
Oh, sorry, I think I went backwards. So just to give you a basic idea of the process, the pilot at this point is only dealing with cases that are already before the court. So one difference for that, from Antoinette's normal day-to-day work is people can opt into the court annexed mediation services, even if their case isn't in court, which is a great service. But for this pilot project, it has to be before the court. And then if the parties agree to participate, so there'd be a discussion in court, the court sends an endorsement to Peel Family Mediation Services. I think one of the things we all recognize as a weakness in our current system is that the parties have to complete two intake forms, one for Peel Family Mediation and one for the OCL. The expectation is that they do that within 7 days. And then the first step is that, and Antoinette, you may want to talk about this a little bit more, is that the Peel Family Mediation screen for intimate partner violence to determine if the case is appropriate.
Right. This is a critical part of our work because any case going through Peel Family Mediation Services, each party has to be screened for IPV before they can even begin any kind of work with us. We have a specific screening tool that we take each party through. And after we've taken them through that, we make a determination about whether the case is appropriate to move forward in mediation. And in this case, with this pilot, the same applies. Even before we contact the Office of the Children's Lawyer, we make that determination. When we make that determination, then we will say to the Office of the Children's Lawyer, well, this is a case that can move through with mediation, and it goes then to the Office of the Children's Lawyer. However, the intake, the endorsement coming from the court, there has to be an endorsement coming to mediation as well as one coming to the Office of the Children's Lawyer. And it could be a little bit of a bottleneck with that, but that's the process that we have at the present time.
Antoinette, I wonder if you could maybe just talk a little bit about why you might say a case isn't appropriate for the mediation.
A case might not be appropriate at times. For example, if parties are in court, they're going through the family process, they might also be going through the criminal process. And there might be an order that says that they're not to be in contact with each other. And if parties are not to be in contact with each other, we cannot work with them together because they would be contradicting the order that they have. So a number of things that could happen is that they can request a variation to the order to work through mediation, or depending on the level of IPV, we might determine that the case is not appropriate at the time to do mediation, because mediation is an amicable process where the parties are working together, sometimes coming face to face. So we make that determination. If there's been a long history of IPV, we might decide not to involve the parties in the mediation because we do not want to cause any further harm to any of the parties or to the children. So those are some of the reasons why we will make a determination whether a case is appropriate to move through or not to move through. Or if someone life is in danger, we will make the decision then that case is not moving through. So those are some of the reasons why we will not proceed.
So once Peel's Family Mediation Services determine that the case is suitable for mediation, the OCL determines if the case should be assigned to a clinician to prepare a voice of the child report or a lawyer to represent the child. So we look at the intake forms, whatever the judge may have endorsed in the record, and a lot of it depends on the age of the child or the children, and determine whether it should be a legal representation where there's an advocacy proponent or component to it, or the voice of the child report, which is simply, I shouldn't say simply, it's never simple, but a written indication to the parties and the mediator and ultimately the court of what the child's views are. So I just want to make it clear that the OCL does not do an investigation or an assessment as part of this pilot project. We meet with the child and report back on what the child has indicated they would like. For VOC reports, they're prepared and provided to the parties and the mediator within 30 days. So that's a pretty tight timeline. And I think we're pretty good about turning them around within 30 days. And then just so you know, the voice of the child reports are filed with the court. So if there's an agreement reached and there's ultimately a final order on consent, the VOC is part of the court record. Just so you know, Section 112 of the Courts of Justice Act actually indicates that the reports are evidence with the court. And then if the case doesn't settle and it has to move forward in litigation, you've got the voice of the child report there already with the court. So you don't have to do it again.
That's something, if I can just say, and
Yeah.
Jane, that's something that we had to take into consideration, that we had to work with that you have an obligation through the courts to file those reports. So we had to take that in putting together this project. We had to take that into consideration.
Right. And if it's a lawyer who's assigned, as a lawyer, we meet with the children to obtain their views and preferences. And I will say this, I seem to say it an awful lot. Lawyers do not prepare reports. So we often, not just in this pilot project, but in other situations where, and it includes lawyers asking us where our report is, lawyers do not prepare reports. The lawyers will participate in the mediation, and depending on the child, they may also participate in the mediation if that's appropriate. And again, it really is going to depend on the child. Sometimes their level of maturity, sometimes the level of conflict, whether they feel confident enough to participate. But some kids want the OCL to be there and state their views and preferences. And sometimes, frankly, what we do is work with our clients to come up with a way to explain their views and preferences in a way that they're comfortable with and that will hopefully be well received by their parents. So we will do that. And then just as an aside, we only deal with parenting issues, not support or property issues. So
Right.
as
Yeah,
far as,
and that piece that Jen is speaking about, we had to take that into close consideration in terms of the lawyer's involvement, because it also had some implications around the agreement to mediate and who signs the agreement to mediate and who does not sign the agreement to mediate. The clinician does not sign the agreement to mediate on. But the lawyer, if the lawyer is going to be involved in the mediation, signs the agreement to mediate form. So we had a lot of discussions on that. And yes, if there are other issues other than parenting issues, we work with the Office of the Children's Lawyer on the parenting issues. And then if there's like support and property issues, then the case is then referred to an off-site mediator who will then work with those other issues. And when we report back to the court, we report on the parenting issues. And then the other issues, if they are resolved, that would then be reported at a later.
so developing the pilot, I think Antoinette alluded to this earlier. The key step was bringing together the necessary stakeholders. And do you want to talk a little bit more about that, Antoinette?
Yes, this took a longer time than we basically expected. But it was important. It was important to have these discussions. So we had discussions with mediators. We had discussions with the Office of Children's Lawyer and Counsel. We had discussions with the judiciary because we needed to get the buy-in from the judiciary, both from the Ontario Court of Justice and the Superior Court of Justice. There's one member of SCJ who basically is a champion of this pilot and fully supports the pilot, and plus all the OCJ judges fully support it. So we needed that support, right, Jane? We needed that support in order for this pilot to take off. And in speaking about it and talking about it and putting it together, we said that there should be some component of research attached to it. And at that time, we discussed, well, who could this researcher be and who would we want to have as a researcher? And that's the time that we made a decision that we would involve Dr. Rachel Birnbaum, having worked at the Children's Lawyer before, having worked on the Voice of the Child reports previously. We thought that she would be an ideal person. She agreed. We contacted her and she readily agreed to participate in the pilot. So she is the researcher for the pilot. So we have two different intake requirements, as we basically indicated before. Our funding structure is slightly different. However, this service that we're offering is free to all participants. So there's no charge to the clients. We've had to be creative in terms of how we can offer the mediation services to these parties free of charge. And that we've worked out with the ministry and OCL. That's part of their role. They offer the free service. And there was some concerns initially about whether the lawyers representing the children should be involved or if that would hinder the process. And we can say proudly today that currently the mediators are embracing the involvement of the lawyers. And it'll be interesting to see what the research says about that piece. But they're finding that the involvement of the lawyers is very, very beneficial.
Yeah, which is great. I think for those of you who are familiar with child protection ADR, hopefully that wouldn't come as a surprise to you. But I think there was some real resistance and anxiety about lawyers taking over the proceeding. The other thing, the factor is we're hoping not to create additional delays for litigants. So that's Brampton is a very busy court. particularly in the SCJ. I mean, last I heard there that to get a conference date, it could take till 2025. So one would think that it would actually be really helpful for parties to engage in this pilot project, if at all possible, because hopefully we can help parties resolve issues. So if we are, I talked about, the next slide is if no resolution is reached, but Antoinette, do you want to talk a little bit more about how it actually works in the mediation?
Yeah, okay. So as we said earlier, once we've determined that a case can proceed to mediation, and then it goes off to the Office of the Children's Lawyer, and they decide whether it'll be a clinician or a lawyer. And then they will meet with the children independently. And there is, from the clinician, there is a report. From the lawyer will speak with the mediator. So then it comes to the mediator to say, this is what the situation is. So a number of things could happen. Sometimes the mediator might have a conversation with the clinician or the lawyer prior to meeting with the parties. And after that, then meetings are set up with the parties to share the information coming from OCL, and then work with the parties to negotiate an agreement. And some interesting things have come out of some of those cases. With some of the cases, there've been some twists, there've been some positive things coming out of it. There's some people, some parties who are not happy with the report coming out of that. And some of the mediators have been able to work through that with them, and some might decide, well, we don't want to continue with that. And that's the reality of life. Not everybody is going to agree what's coming, especially when you're hearing stuff that's coming from a child in terms of their thoughts. But the mediators are quite skilled. And I probably didn't say this earlier. We have mediators with social work backgrounds, psychologists, lawyers. Those are the type of mediators who are working on these cases. Because we do have a core group of mediators who are doing these cases. And they will work with the families to assist them in negotiating the plan. So sometimes there is an agreement, and sometimes parties might decide that they don't want to proceed further. But if they do proceed, I find that we are getting even at least a partial agreement or interim plan in place for future negotiations. And then a report, a mediation summary report, is sent to the court. As Jane said, they send a report, but we send a report as well to the court once we're finished with the case. Now, if they're proceeding, as we said before, to do child support and property, then they move on to the other offsite process of mediation.
And it is a closed mediation, right, Antoinette?
Yes, it is. Oh, yes. All of the mediations in this pilot are closed at the present time. Yeah.
So there would be no reporting back on this mediation failed because this person is uncooperative.
Right. No. Yeah.
Yeah. And I think I have a case right now that we're trying to work through, and there is actually a Métis connection, and we're trying to work out right now how to bring in someone from the Indigenous community to assist us in how we work through the issues. So I am quite intrigued to see how that works.
I am with that case as well too, because specifically the justice is asking that Métis principles be included as part of the negotiation process. So we're all that's a really interesting case, and we're fascinated by it. Another case I can speak about is a case where there's other involvement because there are a number of participants, which is very similar to the child protection mediation case, where you have a number of parties involved with the matter, with different children, different siblings, and different caregivers, etc. We've got a case like that. It's just some interesting stuff is coming out of these cases. So I am really curious and interested in finding out what the research is going to say. Now, sometimes people might move through and decide that they don't want to participate in the research, but we are not sure yet. We'll have to wait to hear from the researcher, like how many people have consented to speak with the researcher and what are the outcomes from that. But there's some fascinating cases that are going through this pilot, which, really would tell us that it is important to do a process like this. We might need to work through some pieces of the process to make it a bit smoother. But based on the cases and the content of the cases, I think it's a valuable pilot.
Yes, and I think we're also trying to be as flexible as we can be, both ends at the OCL and with the mediators to accommodate. As we said earlier, one of the reasons that Brampton was such a great location is because of the diversity. So if one family needs, for example, the Métis principals to be engaged, it's really helpful not to be too rigid in our approach, that we want to make sure that we can accommodate the family's needs wherever possible, including the children's needs. So there have been cases where no resolution is reached. And again, as we've mentioned a few times, if the OCL has prepared a VOC report, that's filed as evidence with the court. If it's a lawyer, then we'll seek the court's permission to allow the lawyer to continue to represent the child or the young person in the court proceeding. And so far, we've been able to do this either on consent at court or by Form 14B motion. So they just send in saying, this matter's not been resolved and the next court date is this date, and can we get the OCL order so that there's authority for the OCL to represent the child. So things we've learned so far. I think we've talked about it a few times already. Requiring the parties to complete 2 separate intake forms causes confusion and delay. Oftentimes, there's a lot of administrative back and forth between the 2 organizations saying, have you got this? Have you got that? And so sometimes the OCL gets the endorsement and the court and the appeal mediation doesn't. So but and trying to make sure that everybody's signed or filled out the intake forms. One of the reasons is that we need enough information in the intake forms from the OCL's perspective to determine whether it should be a VOC or a lawyer. And then from Antoinette's organization, they're looking at, is it an appropriate case for mediation? Is that fair, Antoinette?
Yes, it is. Yes. Mm-hmm. Yeah.
So Antoinette alluded to this already, and so far we are fairly confident that lawyers advocating a child's position doesn't impede resolution. It can sometimes make people annoyed, as same with the VOC reports. The parents can be quite upset when they hear what their children are saying, but it doesn't mean it's a reason not to include the child's voice. And I would imagine the VOC report is valuable evidence in the court. Anything?
Well, we hope. Mm-hmm.
Yeah, we hope. Yeah,
we hope that actually one of the things I could say as well too is that we have had intermittently conversations with the judiciary about the pilot and how it is going and where it is going, and sharing with the judiciary where maybe the roadblocks could be or how we can improve the referral process or the endorsement. And they're very receptive to that. We actually will be having a meeting shortly to update. We provide updates to the judiciary from time to time, and with the researcher in terms of where we're at. What we need to do more is some more advertising to the members of the professional community, specifically to members of the bar, in letting them know what this is all about and providing some explanations about the pilot and what it's basically doing. We do have material flyers that we put out there for the private lawyers. But I believe that we need to do more of that and more to other community agencies that support some of these families. So advertising is critical as well, and we're hoping to do some more of that. And as Jane said, having the lawyer, even if the lawyer is going to be present in the mediation, it has not impede. Actually, it's helpful. The mediators find that the involvement of the lawyer from OCL is a very positive step and a positive approach in this pilot.
Yeah. I think it's interesting to us that there hasn't been more uptake, like for Dr. Birnbaum's research purposes, where we need to get to a certain level, and as she's pointed out to us, this is free. Like, so we hear all these tales, and we certainly know them to be true about the family litigation process and how difficult it is for families and how costly it can be. So it's a little bit puzzling to us that there hasn't been more of a uptake or more of more embrace, that the lawyers in the community are not embracing this more, to say to their clients, this is actually a really valuable tool for you to try to work through this. So do they talk about it in the MIPS, Antoinette? In the mandatory?
They're supposed to, and I need to check it, because we did give a script for it to be delivered at the MIP. Yes.
Yeah. So what we are hoping is that when at the end of the day, that the pilot project the research will show that it has value, and that we could then advocate with the ministry to have similar programs across the province. That's our hope, but we're not there yet. But one of the purposes of talking about it at an event like this is so that other people can start thinking about, how might that make sense in our community?
Now, there are some of the cases where the parties have lawyers.
Yeah.
And in some cases, the parties have opted for their lawyers not to be involved in the process. They're okay with working with the parties, working with the mediator, and the report from the OCL. But I think there were a few that we have where the people's lawyers are involved as well.
Right. Yeah. So those are the sorts of things that we are looking at. So I think Antoinette's already covered.
I think the importance of getting that buy-in from the justices, I think, is critical. It's important, and we do have that support, as I basically indicated to you before. Yeah. And yes, we need to promote more. We find it's valuable to hear that voice from the child. There's great benefit all around to the children and to the families. And we hope with time and with continued work in this, as we can increase the cases. So we're really encouraging the justices to send more cases, and they are working with us on that this will be a beneficial process for families in the long run.
Yeah. And the only thing
somewhere we'll have to do a longitudinal study or something, but we think it could be beneficial.
Right. the other thing that I would say is, for those of you who are in the child protection world, I see a lot. I do the intakes for child protection ADR, and we see an awful lot of child protection ADR, which are really high conflict parenting time cases, where they're so high conflict that the society is involved, and even if there isn't a protection application filed with the court, they're being funneled in that way. Do you see that as well, Antoinette?
Yes, yes, yes. Yeah.
So I think I don't know that Dr. Birnbaum's looking at that in particular, but it is something that I think is probably something that's worth considering, like how many of those child protection ADR cases are cases that where the families are either in court or need to go to court or need someone to help them come up with parenting time arrangements.
Yeah, I've worked as a child protection mediator. Speaking with another hat now,
Yeah.
I've worked on some of those cases,
Yeah.
and we have had some of the OCL lawyers involved, and it's very, very beneficial having them. That has been my experience, actually.
Yeah. And I think, just as an aside, typically we don't get involved with in ADR with a lawyer in child protection for kids who are under the age of 8. Occasionally, we'll hear from the workers that they're very articulate 6 or 7 year olds, and that may be. But with the voice of the child reports, we wouldn't typically be doing it for very young children. We need the children to be able to articulate some of their views. So if people were wondering that. So we've got time for questions, if anyone has any questions. And I'll just put up our contact information.
That was great.
Hi, it's Paulette Lewis. I lost my server during your presentation a little bit, so some of the stuff I did not hear. My question is, I'm wondering if your presentation is going to be available so I can go through it again.
Yes.
Yeah.
Thank you
That's
very
my
much.
understanding, that the
Yeah,
slides.
it's recorded. Yeah, I think it's recorded, so I think you will be able to.
Yeah.
I appreciate
the slides
it.
will be available.
Thank you very much. The slides, I love the slides. Thanks. Bye.
I'm confirming that yes, I have been recording it, and my understanding is it will be uploaded through PAC as well as the slides available to today's participants. Any other questions?
Yeah, go ahead.
No, I was just asking if there are any other questions. This is Gina, the moderator. If anyone has, you can raise your hand or just unmute yourself and ask.
I see a chat. It's a chat here, though. I'm a bit confused on the report process to the court, and especially if mediation is closed, there is time. Will you kindly clarify? I'm not sure who's asking that question.
So the difference between the voice of the child report and the mediation report, that may be so when the clinician speaks to the child, they will speak very briefly to the parents. So it's not like an assessment report that you would see in other situations. It's not a full children's lawyer report. They would just report back on, I met with the child or the children a couple of times. This is what they told me. And they will often make comments about, the child seemed shy or the child seemed forthcoming, those sorts of things. They don't make recommendations in the voice of the child report. It's just there to provide everybody with some sense of what the children's views are. So that's why and because, as I said, Section 112 of the Courts of Justice Act says specifically that a voice of the child report does form evidence in the proceeding. So that piece can go into the court record, but the mediation report is different. It will just say they've either agreed to these things or there was no resolution, right, Antoinette?
Right. Yeah, it's just a summary report. So it just indicates that they've been seeing these are the terms of the agreement, And if there's no agreement, it will just say no agreement. Does not get into any details about if there's no agreement, why there was no agreement. It's just a summary, mediation summary report that's sent back to the court. And the other thing I just wanted to say is that the OCL clinician, when they're involved, would ask, when they're seeing the children, they would have one parent bring the children for one time and the other parent bring the child at another time, right, Jane? That's correct.
That's typically how we like to do it. That's ideal. Sometimes there are impediments to that, but yes, we try to do that. And I think that the reason for that would be fairly obvious, that we just want to make sure that there's consistency between what the kids are saying if they're brought by one parent and brought by the other. The other thing that is sometimes helpful is kids will say, I don't want to be the one to make the decision. And that is a fair comment on their behalf. And that may be what the voice of the child said, you know, that they love both of their parents. They want to spend time with both of their parents. They wish their parents would stop fighting. And sometimes that in and of itself can be very powerful in terms of, you know, as parents think that their kids aren't aware of the conflict, whereas the reality is usually they're very aware of it. And,
right. And the parents are prepped as well. The parents are asked not to reprimand the children based on what is coming from the conversation with them.
Right.
So there is conversation with the parents about how to deal with the whole process. So there's an educative process, like the mediator does a bit of education with the parents even before it's referred to the Office of the Children's Lawyer, just explaining the whole process, the intent behind it, and what is basically involved. So that happens as well.
And we will all, you know, both the mediators and either the clinicians or the lawyers from the OCL will both emphasize to the parents that it's really important that the kids be given permission to just tell us what they think, not be telling the kids what they should tell us, or afterwards grilling them about what they said. What did you tell the lady from the OCL or the man, whatever. Right. So that's an important piece of it. I mean, I'm not naive. I've been doing this a long time. There are still times when parents influence their children, and you know, and if it's a really, really high conflict resistant refuse case, it's sometimes helpful to get a sense from the children of what their views are and why they're taking those views. Again, occasionally you'll hear from kids that they just the conflict was too much for them and they just picked a side. And it's not because one parent was, and I know this term is very controversial, alienating the child or inappropriately influencing it. It's just sometimes that's, you know, that's what it is. And kids are aware when a parent tells them that it's fair that you have to spend 50-50. And sometimes the kids will have very valid reasons. Like one parent lives closer to the school, or one parent helps them with their homework, or, their friends live in that neighborhood, and having to drive and be away from that it doesn't work for the child. And some kids are very clear that it's what they think is fair is 50-50, and for other kids, depending on how they, you know, we have sometimes kids on the spectrum, and for them routine is key, and we try to like, particularly if you were the lawyer, you would be advocating for that, saying you need to look at it from your child's perspective. And I know the mediators do that as well, right, Antoinette?
Yeah, yes. And I mean, there's some children that just want to get away from the conflict, so they would sort of try to suggest certain things just based on what's happening in the family. They lived experience, practically. Any other questions?
I do have one. I just need clarity. So when you said the family litigation, is it free for the family to have this, to work
Yes.
through their conflict?
Yeah. But if they're involved in this pilot, it's free. All the services are free.
Wow, that's great.
Yeah. So that's what we
That's
think. We think
that's
so. We would think
amazing.
that people would be knocking at the door. Yes.
That's amazing. I can take that back. Thank you.
You're welcome.
Paula, were you indicating?
Yeah, I'm just interested in, I mean, voice of the child from my perspective is complicated and controversial. Particularly, I mean, one of the areas where it concerns me is when there has been some harsh parenting and power and control issues and those sorts of things where I'm fearful that there is going to be backlash. I've had that happen a couple of times, despite, doing a lot of education with regard to the importance of not. So I guess I'm just interested in terms of what would be the contraindicators from your perspective. So when would we choose not to do a voice of the child and bring the child's views into the mediation?
Well, you see, this would come from a discussion with the OCL, either clinician or lawyer, in terms of what's happening there. But I can tell you sometimes it could be helpful, because one of the things that can be done is you can do an interim plan to see how something works.
Yep.
And then, when people know that they try something and then they can come back and look at it again, that is sometimes helpful because it helps ease. But then you might also have to include other professionals like therapists or counselors or, people of that nature, where there's more needed other than just going through a negotiation process. You would agree with that, Jane?
Yes. And I would say in not specific to this pilot project, but when we're looking at intake forms or endorsements from judges in I'm going to call them regular parenting time cases, oftentimes if there appears to be some severe estrangement, because I will tell you that virtually every intake form that comes in, someone is alleging alienation.
Oh, yeah.
And, everyone, and oftentimes it's both sides are alleging it. So but if there's a situation where we see that it's particularly troubling, we will, when we have the resources, we will assign that for a Section 112 children's lawyer report, as opposed to a voice of the child. Like typically the voice of the child referrals come in from the court where the parents have agreed. That's what they want to hear from the child.
And Jane, I'm just wondering how you navigate that, because I do a lot of reunification work across various jurisdictions. And we see that, right, where people come and it's like, you don't want it, it's going to make it worse, but then that's what the judge has asked for. So you don't have any ability. Do you have the ability at the OCL, if the court order asks for a voice of the child, do you have the ability to flip it to a 112 or no?
My understanding is that we would typically send in like a Form 14B or something to the court and say we started this as a VOC, or the VOC will come back. I have seen those where the VOC says the issues are such that we think it would be helpful to have a fuller investigation and an assessment rather than simply the voice of the child. It's, not, as we know, there's no panacea. There's no one way that's going to get everything, what each family needs. But, we are also aware sometimes when we have kids who are, truly estranged and there are some difficulties with the independence of those views, that, you know, the OCL have at times got off the record as lawyers because we say we can't be
Yeah.
confident that we're getting that. Sometimes we convert them to a Section 112 children's lawyer report. I mean, it sort of depends on the situation. I mean, it's it's difficult because everyone always alleges that. Like I have this one where, you know, immediately when I say this is what the kids want, well, there must be manipulation there. And I'm like, well, first of all, that's not my job to comment on. But the truth is, I don't actually think there is manipulation there. I think it's a very, very tragic case where the kids have formed a view that is unfortunate from certain parties' perspective. But that's the way it is.
Mhm.
And for the mediation, we might deem a case not appropriate. And then it goes back into the court for the court to make a decision about what's going to happen.
Mhm.
Yeah. Like I imagine if it's one of those really severe resist and refuse cases, Antoinette, that may be one where you'd say,
Yes.
you know, this
Yes.
isn't,
Yeah.
isn't
Yes.
appropriate.
Yeah.
So.
All right, I just want to jump in. It's 12:14. We're at the end of our session. I want to thank Jane and Antoinette for a wonderful presentation, definitely informative, and the questions are indicative of how important this topic is to all of us in this field. So thank you. On behalf of PAC, I thank everyone who participated as well. I do believe Linda popped in and put the links to the main room back in the chat. So we are on lunch from 12:15 until 12:45, and then you can use the link to loop back into the main room for the rest of the afternoon.
Okay. Thank you very
Thank you.
much.
Thank you
Thank
both.
you.
Thank you.
Thanks for
Thank you.
listening.